Generally, adoption creates a legal relationship between children and their adoptive parents and ends the legal relationship between children and their biological parents. In most states, this means that adoptive children cease to be the heirs at law of their biological parents, and thus an adopted child isn't entitled to an intestate share of a biological parent's estate. But do adopted children remain the heirs at law of their biological grandparents? The Washington Supreme Court considered this question in Estates of Donnelly. John and Lily Donnelly had a daughter, Kathleen, and a son. The son died, leaving behind a baby, Jean Louise. Jean Louise's mother remarried, and her new husband adopted Jean Louise. Years later, Lily died, leaving all her property to John. When John died, his will named Lily as his sole beneficiary. Because Lily had predeceased him, John's estate was distributed as if he had died intestate. John and Lily's daughter, Kathleen, served as the administrator of John's estate. Kathleen filed a petition asking a state trial court to determine John's heirs and arguing that, because Jean Louise was adopted, she shouldn't be included as an heir. The trial court found that Jean Louise's adoption had not ended her legal relationship with John. Thus, the court ruled that both Kathleen and Jean Louise were John's heirs. The Court of Appeals affirmed, and Kathleen appealed to the Washington Supreme Court.